Sean.
Good afternoon, everyone. This is First Appearance Court. My name is Steven Zachor. I'll be the judge this afternoon. The purpose of this hearing is to inform you, first of all, what you've been charged with. Second of all, for me to determine whether or not there is probable cause to hold you for these charges. Next, to determine if there are any appropriate release conditions, ranging anywhere from no release to monetary release on monetary conditions, pretrial release, and conditions on your liberty as well. Lastly, you're entitled to a lawyer for these proceedings. I think I saw Mr. Forbarek from the PD's office at the main jail. We have Mr. Afzal here from the public defender's office in the courtroom. And of course, you're welcome to have your own attorney here as well, if you so choose. These proceedings are recorded. Everything is being documented that you say. You have the right to remain silent. No one can make you talk about the charges. So it's in your best interest not to talk about the charges, because if you say something that could be used against you in the future, it'll be audio and video recorded for that purpose. There are members of the state attorney's office here, the prosecuting agency, and if you say something that they like, they'll be able to use it against you in the future. So I suggest you exercise your right to remain silent. Don't talk about the facts of the case. When you do address the court, confine your comments to your ties to the community, how long you've lived in South Florida, friends and family that lived here, whether or not you have a job, own any property, things of that nature. With that being said, Madam Interpreter, what case are you here on?
He's over at North Broward Jail, Judge. They're ready for you.
Okay.
He's on. He's
Mark Crittenden.
Who is it?
What language? Oh. Yes. All right.
Good morning.
Don't be offended.
Foz, who is it?
Ready?
Creedon.
That's interpreter right there?
Sign language interpreter. Yeah.
Yeah.
Lift your hand up higher.
No.
One who doesn't look like they don't.
You want to stand right next to me? Come on over. I can't either.
Maybe was it from this morning? Maybe.
He's like a medical
No.
like some other day or something.
You're moving it off. Gotcha.
We have a French guy for the set. Oh, I know. No. On the weekend. Oh, okay.
All right, Mr. Crittenden, you have a warrant in case number 13-052-394 TC20A. That's for driving on a suspended license.
I understand.
Finish. I'm sorry, I forget you're not there. Yeah, yes, sir. I know that. I understand that.
Okay. Your bond is $500. And no court date has been set as of
Yeah.
yet.
Can the court ask if he has a
I didn't
lawyer?
understand that. I didn't understand that.
Okay. Your bond is $500.
Oh, I know that.
And no court date has been set.
I
set
don't
as
plan
of
the
yet.
bond out.
Okay?
Yes, sir.
All right.
Judge, can I ask a couple questions? Just because.
Well, he said he's going to bond out.
Oh,
That's what he said. Okay. All right. Thank you, sir.
What do you mean? Oh, man, I understand. What you say that again?
Okay, I'm not clear. Can you say it again, please?
Say it again. Say it again.
You have a
Say it again.
$500
Say
bond.
what you just said again. No, not the bond. What you said after?
After the bond.
There's no court date set yet.
What that means? What does that mean? Spell that. Oh, so my question is, what happens after this, sir?
I don't.
What happens after this? I mean, am I to plead or?
You have a
know, like I did
$500
last
bond.
time?
You can bond out.
I'm not bonding out.
Oh, I thought you said you were bonding
I'm
out.
just stay here till it's all done.
Okay.
You know, I just
Can
want
I-
to get over it.
Hey, give me 1 second. Was this was a recent hearing?
It's reset from Saturday. Yes, it was.
I was here on Saturday, so I remember that story.
Yeah.
I'm looking at, sir. I'm looking at your
Okay,
driver's
I'm
record.
trying to see you. I don't have my glasses.
That's
I
okay.
don't have my glasses, that's why I'm looking up.
Oh, whenever you're ready. Yeah, I'm good. Do you need this? Yeah.
You know, my driver's license was suspended the last time I was here. This is my second time here on the same
No, no.
day.
I'm looking at your record. It shows he has no prior convictions or withholds for DWLS. Do you want to resolve the charges this afternoon?
Can you see, Doggy?
I want yeah, I do.
Okay.
Yes, I do.
Do you want to give up your constitutional rights?
Yes, sir.
And enter a
Yes,
plea?
sir. That's fine.
All right. How do you plead?
Say that again.
How do you plead? What's your plea? Guilty, not guilty, no contest.
Guilty.
All right. I will accept your guilty plea and sentence you to an adjudication and time served.
Yeah, I accept.
Okay. Me too.
Thank you.
You're all done.
There you go.
Thank you, ma'am. I signed your sheet. You have a case, sir?
Yes, Judge. Jelani Davis standing in for Jarrell Lawrence. I believe you have Regina Lynn on your 130 docket.
Regina Lynn?
Yeah.
Regina Lynn? Did you talk to her?
Yes.
What do I say?
Good afternoon, Miss Lynn.
Oh, good afternoon.
You've been charged with one count. It's a county ordinance, disorderly conduct. I've reviewed the probable cause affidavit. I do find probable cause. There's an attorney here on behalf. I'm sorry, counsel, your name?
Jelani Davis standing in for Jarrell McLawrence.
Okay, Mr. Davis is standing in for Mr. McLawrence. You had a chance to speak to Mr. Davis, so what's her pleasure, Mr. Davis?
Judge, we'd like to close this out. There's an offer by the state of the court. We'd like to close it out.
Okay. Ms. Lynn, your attorney says you'd like to resolve the charges today?
Yes.
Does she have any kind of a record? Could you look her up?
I could check.
All right, Miss Lynn, raise your right hand. You swear or affirm the testimony you're about to give is the truth?
Yes.
All right, you can put your hand down, ma'am. If you resolve these charges, you'd be giving up your constitutional rights. For instance, you'd be giving up your presumption of innocence. You'd be giving up your right to a trial, the right to have an attorney such as Mr. Davis or Mr. McLawrence represent you at that trial, the right to confront the city's witnesses, and the right to call your own witnesses. Are you willing to give up those rights and resolve the charges this afternoon?
Yes.
How do you plead, ma'am?
No contest.
All right, I'll accept your no contest plea.
I just need her BCCN number.
776655.
776655. As far as Broward goes, the only things I see prior to this, she got a DWLS in 09.
All right, ma'am. I'm going to withhold adjudication. You're going to have to pay whatever court costs are appropriate, and you're all set, okay?
Okay.
Good luck to you, ma'am. Good luck to you. Anything else, Mr. Davis?
We have one more. That might have been Mr. Stinson, but I think John Stinson, page 2 on the documents.
Is that second looks?
Yes.
Let your attorney know that. I don't know the answer.
John Stinson.
I wasn't judge, was no.
You gonna hire one or get one? Yeah, but just let them know. They can talk to you. So,
Mr. Favara, do you have a John Stinson there?
let me check, Judge. John Smith? I don't remember that.
No.
They're looking. No? Not on the second list, are you? No, they don't have it on the list, Judge.
Is there a John Stinson at Conti?
Yes, sir. Yeah, found him.
And you said you didn't have a chance to talk to him? No. Okay. Mr. Stinson, looks like you've been in custody 5 days for a municipal ordinance. Anybody know what that is?
Lodging in a public park.
Okay, we're sleeping in a park in the city of Fort Lauderdale, I guess. Oh no, Hollywood. Sorry.
That's Hollywood.
Just Hollywood, yeah. Although it's a 10 case, usually the MO10s are. You know what your bond is, Mr. Stinson?
Yes,
What is it?
$100 bond.
Okay, can you afford that bond?
No, not at the moment.
You interested in resolving the charges?
Yes,
All right, raise your right hand. You swear or affirm the testimony you're about to give is the truth?
yes,
Put your hand down. If you resolve these charges, you'd be giving up your constitutional rights. For instance, you'd be giving up the fact that you're presumed innocent. You'd be giving up your right to a trial, the right to a lawyer at that trial, the right to confront the city's witnesses, the right to call your own witnesses. You want to give up those rights and resolve the charges this afternoon?
yes.
All right, how do you plead, sir?
No contest.
I'll accept your no contest plea and sentence you to an adjudication in time served. You're all set, sir.
Judge Court, he has a, that was on the MO case.
Right.
He's being held on the 6th, that's the.
Oh, okay. With only the MOs at one. What do you have, sir?
I have Mr. Walter Williams. How are you, Your Honor?
I'm well, thanks. Walter
Sorry
Williams.
for not wearing a tie.
No worries.
I've been like this all day. That's right.
Walter Williams?
Three. He may have been transferred out to one of the other jails.
You know where he is?
Mr. Linder, on your paperwork, I saw it said...
Page 3 on the
I
top.
thought he was actually-
I'm checking right now where he is.
Judge, he's at Paul Ryan.
Is there a Walter Williams and Paul Ryan?
Should be.
Is there anyone answering at Paul Ryan?
If you can hear me at Paul Ryan, give me a wave. I see a smile. Can you wave in the back right-hand corner?
One second, Your Honor. I'll look.
Thank
I'm
you,
sorry.
ma'am.
It's,
He's here, Your Honor. I'll have him
Thank
come
you.
down.
Okay.
You want me to have a seat?
She has to come down.
I think that's what she said.
yeah.
Unless she's coming down from something right next door. Because I don't know.
We're never that lucky.
We'll move on. Kenneth Forbes? Good afternoon, Mr. Forbes. You've been arrested and charged with 1 count of domestic violence battery, 1 count of possession of marijuana. I have reviewed the probable cause affidavit. I do find probable cause. Any criminal history on Mr. Forbes?
One moment, Your Honor. Do you have anything? I got it.
Victim contact?
There was contact, Your Honor. The victim has no safety concerns.
2011 battery, 09 and 08 possession of marijuana, 07 resisting without violence and trespass, 03 trespass.
Mr. Barrick?
Judge, I can tell the court that he's lived here all of his life, that he's single, he has 2 children that are aged 11 and 1. He has 2 different jobs that he works, a car detailing job as well as he does promotions. He only had $18 when he was arrested. He says that all of his family is here, and he's hoping that they'll be able to help him. We would just ask the court to set a minimal bond.
All right. It's going to be a $1,000 bond on count 1. There's no charge for count 2. For the time being, he's to have no contact directly or indirectly with Nadine, Marcia, Goldblum.
Okay, it's $100 to if you go through a bond, it's $100.
Leonard Platt?
Repeat that.
Sure. You step this way. If you go through a bond, it's $100.
$100.
We're not going to forget about you. No, I understand that. That's it. Correct.
Mr. Platt?
No, not at all.
You have some ad charges. Looks like 3 separate cases for violation of an injunction for protection against domestic violence. Those are in case numbers 1400 1000 MM10A, 1400 6299 MM10A, and 1400 6300 MM10A.
This is actually ours. It's county ordinance.
Oh, it's ours?
Hey. Yeah. Whatever. What's that? Well, apparently it was other people.
So these are no bond warrants by Judge McHugh.
Yes, Judge.
All right, so they'll be held no bond on count 5, 6, and 7. You'll see Judge McHugh. No court date as of yet. Catherine Nesbitt.
Your Honor, I'll wait till after this case. Okay.
That's why it sounds familiar.
Your Honor,
Reset.
there are people present that I believe the case are here on. It says no paperwork on the docket.
Okay. The two folks that are
Your Judge Shakur, is that Boarhead?
No, Nesbitt.
Oh, Nesbitt's out on loan.
All right, thank you. What's the first name?
Danielle.
Danielle Carter. On which docket?
No, it's domestic.
All right, so she's not getting magistrate till tomorrow? She's not going to have her first appearance hearing until tomorrow morning or tomorrow afternoon?
Morning, it should be.
Be on the morning docket.
Okay, I have a problem here.
Okay? I don't deal with problems, but...
No, this is a serious problem because the guy that she has an issue with, he's threatened to kill my grandchildren. And they're there.
He's the victim in the alleged domestic violence?
Yes.
All right. The only thing I can tell you at this point is you need to call the police.
Okay.
If you feel that people are in danger, there's no choice but to call the police.
I'm still fascinated how she got a domestic violence. She had a black eye. I can't.
Sir, I know nothing about it because the paperwork's not here. So, all I can tell you is that depending on when they get arrested determines on when they get on the docket.
Yeah,
she'll have her hearing tomorrow morning.
She's breaking her life on several occasions. This man started in Dade County. You know, the Broward County.
Make sure you come back tomorrow
Okay.
when the hearing happens.
What time?
What time does Judge Hurley start typically?
8:30, give or take.
Does he actually start at 8:30?
Give or take.
All right, so be here at 8:30. There'll be a different judge here. I only do this on Mondays, all right?
So,
But that's fine, because I don't know anything about the case, so it's not like you're losing anything by having a different judge.
Okay, so
But if you feel there's a danger, you need to call the police. It's just no other way around it.
Well, I'm gonna do that right now, so because Okay. All
Okay?
right. All right.
Okay. Demetrius Bellamy.
Judge, he declined the public defender.
Okay, good afternoon, Mr. Bellamy. You've been arrested and charged with one count of driving under the influence. They say it's your first offense. I reviewed the probable cause affidavit. I do find probable cause. Your bond is $500, sir. Peter Foley. Good afternoon,
Judge, he
Mr.
also,
Foley. You're charged
Mr.
on count
Foley
one,
indicated he was
driving under the influence. Count 2 is having a blood alcohol level in excess of 0.15. Count 3 and 4 are traffic tickets for unlawful speed and improper lane change.
Judge, Mr. Foley also indicated he was going to hire private counsel.
Okay. Mr. Foley, did you want to hire private counsel for this hearing?
No.
Okay. You're gonna.
Yeah, I know. I can't tell the judge
All right,
when to
so
talk.
I have reviewed the probable cause affidavit. I do find probable cause for all charges. Your bond in count 1, the DUI is $500. Your bond in count 2, the enhanced DUI is $1,000. There's no charge for the additional counts 3 and 4. So your total bond is $1,500.
Thank you, Your Honor.
Russell Newby.
Yes, sir.
Good afternoon, sir. You have a warrant. In the first case, it's Municipal Ordinance 16-000-335. Looks like that's for open consumption of alcohol. And the second warrant is case number 15-013-208, MM10A. Looks like that's for a trespass. Your bond is $100 on count 1 and $250 on count 2.
Judge, with the court appoint counsel on count 1.
Anybody know what city this is?
I don't
I
know.
can find out.
Is there an open park?
Judge, the problem is with Oakland Park is that they don't provide lawyers for people that are indigent.
soon as he
Well,
finishes.
he could be languishing in the jail just on this count.
Pompano Beach.
Yes, sir, Your Honor.
Who
They
does,
don't
one
all-
second. Who does Pompano?
Nobody.
Who does Pompano get it?
Can I resolve?
Yes, sir, Your Honor. Can I resolve the case?
Why is bond so high?
I guess it's just where.
You see what's going on?
Just where they were set.
Funny that they.
Any reason I shouldn't resolve them?
None from me.
All right, Mr. Newby, you want to resolve the charges?
Yes, sir, Your Honor.
All right, raise your right hand. You swear affirm the testimony you're about to give is the truth?
Yes, sir, I do.
Put your hand down, please. Understand by resolving these charges, you'd be giving up your right to contest them in court. You'd be giving up your right to a trial, the right to a lawyer at that trial, the right to call your own witnesses, the right to confront the state or the city's witnesses. You'd also be giving up the fact that you're presumed innocent of these charges. You want to give up all those rights?
Yes, sir, I do.
How do you plead as to both charges?
No contest, Your Honor.
All right, I'll accept that no contest plea, and I will sentence you to an adjudication in the time you've already served on both cases.
All right, thank you very much, sir.
Good luck to you, sir. Good luck. Winstead Clint Turnbull.
Main Joe.
Good afternoon, Mr. Turnbull. You're charged with one count of domestic violence battery. I reviewed the probable cause affidavit. I do find probable cause. Any criminal history for Mr. Turnbull?
1 minute, Judge.
Any contact?
Wouldn't have. He had a 2010 out of date disorderly conduct, and 09 he went through drug court in Broward on felony possession of marijuana, successful completion. 02 resisting without violence in Broward. End of record.
Okay, Mr. Farbar.
Judge, I can tell the court that he's lived here for approximately 15 years. He singly has two children that are aged 2 and 9. He has about $500 in the bank. He has two jobs. He does fiber optics installation. He also is a computer technician. His family all lives here. He's not sure if they're going to be able to help him. I can tell the court he indicated he's never failed to appear for court before. And I would just ask the court to take into consideration that his last charge that the state indicated was in 2010. It was 6 years ago. And he only has 2 misdemeanors on his record. So I would ask the court to take that into consideration and consider releasing him ROR.
All right, I'm not going to ROR him, but I will set a $500 bond. As a condition of the bond, there's to be no contact directly or indirectly with Tracy Ann Amisa Chung.
Okay.
Paul Javon Morleggett.
He bonded.
What was
Kentrell. Oh, let me see, is that other guy here? There he is. Mr. Walter Williams.
All right,
Step on up, Mr. Williams.
I don't know who it's assigned to, so I couldn't.
All right,
tell
Mr.
you.
Williams, have some ad charges here. Counsel, what's your name again?
Eric Clayman.
Eric Clayman is here on your behalf.
Yes, sir.
Looks like you've already been magistrated on count 1. You're in on a $10,000 bond. I see 3 and 4 here. What's count 2?
Well, Your Honor, count 2, he came back on Friday before Judge Brown. It was an ad charge of assault. You magistrated him on Thursday.
Right, I see that.
And
They were a day apart, which was first, I forgot. The assault may have predated by 1 day the battery, or it was the other way around. One of the two.
What did Judge Brown set on the assault?
5,000.
So he's total right now. He's looking at 15,000 in total.
And there were a host of pretrial conditions, and Judge Brown also wanted no alcohol, intoxicants, things of that nature, ankle monitor. And what I gave to before we proceed, Your Honor, what I let Judge Brown know was I've known Mr. Williams for some time. I also know the victim, Ms. Beckton. In the prior case, Ms. Beckton's actually hired me on more than one occasion to represent Mr. Williams. In this particular case, I asked Ms. Beckton what she felt comfortable with. Did she want Walt to be out, even though it's not necessarily her decision? She did state that she's fine with him out, but she would want him to be on a monitor so he could be held accountable for where he's at, because she does not want to continue a relationship with him at this time. So that's the last thing that we discussed while we were here in front of Judge Brown, while Ms. Beckton was present. Her son was here, and there was actually a detective, Detective Doyle, the same gentleman who drafted this PC, who was here for that particular hearing the following day.
And Your Honor, all I can tell you, and ultimately what happens today is up to you. I spoke to the victim, and I don't know if there was just confusion. I don't know. All I can tell you is what she told me was that what she thought was being told to her, and you don't fault Mr. Clayman by any means. I think it might, from her end, it felt like a miscommunication, is that he was definitely going to get a bond, and if that was the case, she wanted him on a GPS monitor. What she conveyed to me, if it was up to her, she is very concerned for her safety and the safety of her child, and if it was up to her, that he wouldn't get a bond. So, frankly, I'm not formally moving to revoke bond. It's up to you how you choose to respond at this point on an allegation of violation of your pretrial release conditions that you set on Thursday.
If I may say one thing, Judge, just before you decide to make a decision.
Yeah, let me just ask a question so I have it.
Sure.
Count 4 is the violation of the condition I said of no contact, right?
As I understand it.
What's count 3?
Count 3, she also got an injunction, and that was served while he was in custody also.
Okay.
Just want to get on her own. Just so we're clear, Judge, just so
Yeah,
you're
go ahead,
aware,
Mr.
and Mr. Linder, and I could provide it for Eric, or Mr. Linder, I let him know last time. I have a text message from Ms. Beckton to me personally, just so there's absolutely no misunderstandings.
And I want to put on the record, I do not think that Mr. Clayman is misrepresenting anything to the court. Strictly, I know. And what I'm saying is, and I have no doubt that she texted him what he's representing. I'm just telling you what she told me was she misunderstood. But ultimately, it's up to the court.
I do know, just for what it's worth, that Ms. Beckton and Mr. Williams have had some hiccups in the past. Some have been alleged to have been physical, where in reality, there was no physicality. And then I've dealt with Ms. Beckton, I've dealt with Ms. Williams, and we've gone forward from that point. So it's going to be kind of difficult from your position to make that decision, because you have his record in front of you and you see.
I only know what I know, and there'll be a future judge and future lawyers that will know a lot more about it than I do. But what I know for at this point is that I do find probable cause for both counts 3 and 4. As to count 3, I'm going to impose a $5,000 bond, and there will be a monitor. There already is a monitor, but there'll be a monitor on that count. There will continue to be, for what it's worth, no contact
Ms. Beckton.
with Ms. Beckton. Count 4, which is a violation of the pretrial release conditions that I imposed, which apparently lasted, if I read the probable cause affidavit, less than 20 minutes. So right after I told him to have no contact with Ms. Beckton, he completely defied my order, and before he even had a chance to bond out, contacted Ms. Beckton.
Judge, can I say something?
No, not right now. It's not in your best interest. Mr. Clayman's doing a fine job for you. Let him continue to do that job.
Thank you.
So, I mean, if there's ever evidence that someone's not going to abide by the rules, or they do it before they even get out of jail, had it be fresh in his head, I said not to contact her. So I'm going to revoke the bond on that case.
If I could say one thing to that.
You may.
To that position, Judge, and it may sound like a strange argument, but since the court is moving to revoke based on a violation of a pretrial release condition, I'd argue that hasn't been violated because Mr. Williams hasn't been released. He's still in custody, he's still in the jail. He hasn't had the opportunity to make a bond or get out at that point in time.
I think that's a very good argument. I don't think it's a silly argument, but it doesn't persuade me. I'm going to revoke his bond because he was not to have any contact from the moment he walked away from that podium, and he did.
And Your Honor, I just want to say, and I don't have, and unfortunately I don't have the site in front of me, but I do know for a fact the courts have addressed this, and your release conditions actually go into effect the moment that a judge orders them, whether you're in custody or not in custody at the time that they're allegedly violated. And that they can be found to be, a defendant can be found to be in violation, even while they're in custody. Well, actually, it would be count 1 that you'd be revoking.
Right, I'd be revoking the bond on count 1. I didn't impose the bond on count 2. It was only the bond on count 1 that I'd be revoking.
He wasn't being held on count 2 when the alleged.
Right, correct. Right, so count 1, that bond is revoked.
Which would be the battery.
The battery
The
separate
felony
second
battery,
subject
yeah.
offense, correct.
Okay, is that gonna be count 4 and no bond?
Count 4 doesn't get any bond.
Okay.
Yeah, yes, it does.
It needs a bond.
It does need a bond?
Yes, count 4 does.
Putting no bond on count 4?
No, I can't.
No, you
put it
can't.
on
He's
count
bond
4.
eligible.
No, that's it. You not give him a bond on that one and just leave it as is if you're willing to, because no matter how it is,
Well,
at this
right
point,
now
he can't afford to pay any
Right
of the
now, it
bonds.
might as well be no bond because it's set at hearing for me. So if I
Regardless.
don't put something, it'll be held as no bond until some judge puts something.
No, understood.
You're
It
asking me
came
to
out the
ROR.
wrong way. I meant if you would be willing to, at least on that final particular count, ROR him on the count, because he's not going to be able to make these financial conditions
That is-
regardless, which is the problem that we have.
Well, number 1 is the no bond. On count 4, though, what I'm going to do is I'm going to basically put in the bond that was on number 1. It's going to be a $10,000 bond. GPS monitoring, level 2, no contact.
Well, I'll come see you at the jail.
So
We'll
count
talk
1
about
is
it,
now
okay?
revoked, no bond. Count 2, I believe, was 5,000. I was told. Is that right?
Count 2 is 5,000.
So now count 3 is 5,000. Count 4 is 10,000. And now it's all for Mr. Clayman to sort out.
It is. I look forward to it.
Yes.
Fucked up.
Kentrell Rashad Bryant.
Your Honor, thanks for your time.
Thank you. Sorry for the wait.
Yeah, absolutely.
Mr. Bryant, you're charged in count 1 with possession of a short-barreled shotgun, or short-barreled gun or machine gun. Count 2, driving on a suspended license, first offense. Count 3 is a traffic ticket for unauthorized display of a blue or red light.
Do you have anything? Yeah.
Took off
I don't know. Just, thank you.
I don't know. I'm not a convicted felon, so I don't see why. No, you're not charged with.
Where's Brian? On the office.
I'm finishing off right now. I gotta finish this order first.
Brian's not having.
Okay, I do find probable cause for all 3. Thank you, Mark.
Arch, can you wait here for just 1 second? There's something you need, if you could fax for me. Can I get the rate? All right. I'll take whatever I can get.
Any criminal history on behalf of
No
Mr.
priors,
Bryant?
Your Honor.
No priors?
No.
You know what? I can do that for you.
Mr. Forbarek?
Okay. What I need
Judge, I would
is-
just indicate to the court, he's lived here for approximately 21 years. He is single. He has 1 child that's aged 3 years old. He has, how much money do you have in the bank?
That's like $200.
He has a few $100s in the bank. He currently works 2 different jobs. He works at Joe's Crab Shack. He also works at a tree company, and he says that both of those jobs should still be available to him. Everyone in his family is here. He's got brothers, sisters, aunts, uncles. All of his family is here. He also indicated that he's hopeful that his family will help him. And he also indicated to me that he is, are you in college or going to college?
I'm almost finished with college.
And where do you go?
I go to Broward College.
Okay. So he's almost finished with Broward College. He's attending right now.
For paramedic.
You're almost finished with a 2-year degree or a 4-year degree?
Currently, right now, I finished with my AA in science, and I'm just have to complete my EMT program, and then I'm done with college completely.
Okay. And you want to be an EMT? That's the goal?
I'm already in the EMT program. I'm waiting for spring break to be over to start my classes.
Okay.
Judge, in light of the fact that he's still in college and that he has no prior record, I would ask the court if the court would consider releasing him ROR.
All right, I'm going to release you ROR, pretrial release. Standard conditions. Okay.
Thank you very much, Judge.
Thank you.
Larry Johnson. Good afternoon, Mr. Johnson. You've been arrested and charged with petty theft. You say you have more than 3 prior convictions. That makes this what would be a misdemeanor, makes it a felony. I do find probable cause. Your bond is $750.
Literally right across the street. Right now? Yeah, tomorrow. Unless you won't get out before 5 probably. So tomorrow morning, first thing. Okay?
Okay.
All right. Good luck to you.
It's from 2013. That'll be interpreter will be here about 2:30.
Adley.
That was when we reset from this morning. I gave you the report.
Yeah, I know.
Oh, okay.
Adley Duplessis.
Judge, I refuse the probable cause. I don't have a probable cause objection.
Is there a Mr. Duplessis anywhere?
Hey, Joe. What's your name?
Adley.
This is Mr. Adley?
Oh, Adley's the last name?
Duplessis.
Duplessis, that's what I thought. Mr. Duplessis. Okay, you've been charged with 1 count of lewd lascivious act on a victim over the age of 12 years. I have reviewed the probable cause affidavit. I do find probable cause. See any criminal history?
One moment, Your Honor. I want to see what this injunction's about. Yeah, you're probably right, but I want to make sure. It's not. It's on behalf of.
This morning, okay. Okay.
No priors.
Thank you.
No priors? Okay. Mr. Forbarek?
Judge, I apologize. He wasn't on my docket. I didn't realize he was from this morning. If I can have just a minute to talk to him?
Sure.
Thank you.
Dwayne Strickland? Good afternoon, Mr. Strickland. You have a municipal ordinance.
I know. I'd like to resolve it, sir.
Okay. It's for open consumption of alcohol.
Yeah, I know.
Case number 15-001-794-MO30A.
Yes, sir. Yes, sir.
And you want to resolve it?
I do, sir.
How do you want to resolve it?
No contest.
Okay. I'll accept your no contest plea and sentence you to an adjudication in time served.
Thank you, sir.
You're welcome.
They usually do
That's
those.
all I've been
Yeah,
waiting
I know, I hear you.
Mr. Forbarek, we need to recall Larry Johnson. Is he still there?
Okay. He is. Mr. Johnson? Yes. Can you write this? Yep.
All right, Mr. Johnson, sounds like you were out on pretrial services, being supervised by pretrial services for the offense of strong-armed robbery in case number 13-006-785-CF10A. I found probable cause that you committed a new petty theft while out on pretrial services. Therefore, I'm going to revoke your pretrial services in case number 13-006-785-CF10A, and you'll be held no bond on that case. Your $750 bond on the new charge still remains the same.
Okay, you understand?
You said 2:30 for the French interpreter?
It'll freeze like that. Yes.
2:30?
Yes, that's what I was told.
I'm gonna go. Who do you have at Conti? What's your name, sir? Turn on the microphone. Press that little button in front of you.
Samuel Kaplan.
It's his fault.
Samuel Kaplan?
Yes, sir.
It's a 30-day, Mr. Linder.
One moment, Your Honor.
According to this, it's a 46-day. Looks like you've been in custody for petty theft. Let us look it up, okay?
Yes, sir.
Kaplan.
Samuel Kaplan, page 2 of the...
Yeah, he can be ROR'd on this.
Mr. Kaplan, they tell me that the charges have not been filed against you as of yet. Therefore, you're entitled to an ROR on this case. If you have any other cases holding you, it doesn't affect that.
I think they're good. I think the charge is going to be filed, so he just needs to be on the lookout for it.
Looks like the charges will be filed, but because they haven't been filed yet, you don't have to wait in jail any longer. So if you do get released because nothing else is holding you, then you need to be proactive. Because if you miss a court date, you're just going to end up with a warrant, end up right back where you are. So check the clerk of courts. Make sure you check your mailbox. Got it?
Yes.
He still has a no bond.
Can I get
Sounds like you have a no bond hold on something else, so I just wasted my breath.
Yeah.
But you are on this case. Okay?
Can I resolve it?
No, it's not filed yet. It's a felony. I can't resolve felonies here. I'm not qualified. Your name, sir?
Kevin Haig, sir.
Kevin Haig. You've been in custody as well. Delivery of cocaine within 1,000 feet, possession of cocaine, and drug paraphernalia. We'll look it up.
Entitled to ROR.
You also are entitled to ROR. Doesn't mean the charges won't get filed. You just don't have to wait in jail any longer. So if there's nothing else holding you, you'll be released on your own recognizance, but you have to be proactive. Check the clerk of court's computer. Check your mailbox. That way you don't miss any court dates. Okay?
Yes, sir. John, I have no hold bond. Is there any way that I can get my bond back so I can bond out, sir?
You're going to have your attorney revisit that with the judge that's holding you no bond.
Okay, thank you, sir. All right, thank you.
Anybody else at Conti?
Yeah, but I'm expecting a fax.
No, thank you very much.
You're welcome. Let's go to Paul Ryan.
Good afternoon, Your Honor. We can recall Mr. Duplessis from this morning's docket, page 20.
Oh, he's ready? Okay.
Hey, it's Eric.
We're ready.
All right, Mr. Duplessis, I do find probable cause for the offense of lewd and lascivious act on a victim in excess of 12 years of age. Mr. Reedy?
Yes, Judge. Mr. Duplessis has lived here all of his life. He's 19 years old. He's employed at Walmart.
Yeah.
He has family here in the area.
Okay.
His aunt, uncle, his entire family is here. They have access to about $800 in cash that they could put toward a bond. It's his first offense ever, from what he tells me.
I'll just fax you.
He's a registered voter,
Email the info right now. Okay.
and he graduated from the Christian Learning Academy.
Okay. All right, thanks.
Okay. Did I ask you about his history?
I'm sorry, he has no history.
No history. And did you say he was living at home, Mr. Reedy?
Are you living at home?
Yes, sir.
Yes, he is, Judge.
Who are you living with, sir?
My uncle.
He lives with his uncle.
When you graduated high school, were you also going to college of any sort, or were you working at Walmart?
I was working at Walmart.
All right. I'm going to impose a $1,500 bond. Sir, you're to have no contact with the listed victim, you know who that is, or with her family. Understood?
Yes, sir.
Sounds like that hasn't been a problem for the last few months anyway, but now it's official. Okay? So no contact with the victim or her family. Understood?
Yes, sir.
Okay.
Okay. Thank you, Judge. No contact.
All right. Where was I? Where was Paul
It doesn't
Ryan?
matter.
All right, Paul Ryan, who's up?
We still need the facts upstairs.
Brennan. Brennan?
Brennan Strine.
Brennan Strine, you've been in custody for possession of cocaine.
One moment. Strine. He's entitled to an ROR.
Mr. Strine, the charges have not been filed against you within the requisite time period. You're entitled to an ROR. You'll be released on your own recognizance if there's nothing else holding you. However, charges may be filed. You need to be proactive. Check the clerk's computer, check your mailbox, because that way if charges are filed, you don't want to miss any court date and end up with a no bond warrant, okay?
Yes, sir.
Good luck to you, sir.
Thank you.
And Trinell Maynard?
What's your name, ma'am?
Trinell Maynard.
Trinell Maynard, you've been in custody for possession of PVP, otherwise known as Flocka.
One moment, Judge. One moment. Just needs to be reset for Wednesday, Judge. That'll be the 33rd day.
All right, we're going to reset your case for Wednesday. Okay, we'll see you Wednesday afternoon. Anybody else at Paul Ryan?
No, sir, that's all.
What you got at North?
That's it.
No,
For the Paul Ryan.
Colby, come on. I got Colby. Christopher Colby.
Mr. Colby, you've been in custody for possession of cocaine and for a traffic ticket.
Yes, sir.
He can be ROR'd.
The charges have not been filed against you as of yet. You're entitled to an ROR. If there's nothing else holding you, you will be released. Need to be proactive. Check the clerk's computer. Check your mailbox. Make sure you don't miss a court date because charges may be filed against you.
Yes, sir.
All right. Good luck to you, sir.
Thank you. Come on, Sanchez.
Sanchez, Gabriel.
Gabriel Sanchez, you've been in custody for grand theft and uttering a false instrument.
Yes, sir.
Looks like it's going to be declined.
All right. Looks like the charges are going to be declined, so you're entitled to the ultimate ROR.
Decline. What's that mean, sir? I don't.
Good sign, guy. You're going home.
Okay, thank you.
See,
Thank you.
That's what that means.
Decline. What's decline mean?
The
going
state
home,
attorney's
that's what it
office
means.
is declining the opportunity to charge you with a criminal offense.
That means no. They dropped it.
Yes.
Oh, thank you.
Don't thank me. I didn't do it.
God bless everybody.
Thank you. We could all use it.
Go back, have a seat yourself. Come on, Jackson. Jackson Nicholas.
Nicholas Jackson,
Misdemeanor.
you've been here 5 days on a petty theft.
Yes, sir.
What's your bond, sir?
$25.
Oh, you're going to see Judge Lerner Wren. I remember you. Did you see Judge Lerner Wren yet?
Yes.
When?
Daddy, what now?
Did you see another judge yet?
He's got his status tomorrow morning.
All right, you're going to see Judge Lerner Wren tomorrow. Is that on this case?
Yes.
So this has already been transferred?
Yes.
Okay, this is Nicholas Jackson. You're going to see your judge tomorrow.
Okay.
All right, good luck to you, sir.
Thank you.
Anybody else at North? All right, see you next week.
Have a good day. Have a good week.
Resfon, Judge, there was a person, Cheryl Resfon, on the second look. She's over at North Broward. Can I just ask the court to reset that for tomorrow?
Sure.
Yeah, we
When
reset
she-
You don't have any females there at North?
She was a medical reset last time.
I already talked to.
Oh, you talked to him, okay. Yeah, we'll
I
reset it for
talked to him
tomorrow.
down there.
Okay.
Okay.
We'll reset it. I don't have any paperwork on her, but
Well, I can tell you Filarski's.
we'll set it tomorrow. Okay. All right, Mr. Farbarik, Mr. Reedy, you still there? Who's next?
Yes, it's right here. Come on up. What's your name?
Ryan Filarski.
Mr. Vilarski?
Mr. Filarski is still here, 6 days on commercial use of the state right away. What's your bond, Mr. Filarski?
$25. homeless, and I ain't got no money to pay it.
Okay.
Is there any way I can resolve this today?
I'm not comfortable resolving your charges, Mr. Filarski. I think you made it, what, 24 hours last time? I guess you don't have to answer that, but I remember I saw you twice in 1 week. So.
Yeah, I was crossing on this event. I was crossing the street eating chicken wings.
Sounds like a valid defense. All right, I'm not inclined to alter Mr. Filarski's bond or resolve the charges. So set in division, yes. As long as it's set.
That's it.
Marco Burgos, sorry.
Sir, yes, sir.
What's your bond, sir? You have 3 charges of assault on an officer or a firefighter?
$100 bond, sir, and I can't afford it.
$100 total or 100 on each?
100 on one. I like to resolve it if we can.
I don't know anything about the facts of your case,
I can
based on the charges. I don't know that I'd be.
I can print out the report for you.
Hold on, they're going to give me a copy of the police report so I can take a look at it.
Sir, yes, sir.
Could you grab that for me, Kifa, please? That's what we're doing. That's where we're going.
Where?
All right, I just got it. Let me take a look at it, Mr. Burgos.
Sir, yes, sir.
She wants to talk to you. She was very happy. Huh? Paul was, Serena was calling us to say bye-bye this morning. That's what she called him. You know, said I don't want to tell them. Changed her mind.
All right, Mr. Linder, any idea what his history is?
Yes, Judge, I do. It is 2014 DUI property damage, 2013 grand theft auto, 16 and a half months as a HO, trespass 2011, disorderly intoxication 2011, trespass 2011, aggravated fleeing and eluding 02, 7 years HO, abusing or neglecting an elderly person or disabled adult, bat Leo, resisting with violence in 02, 7 years HO and PRR, paraphernalia 02, theft 02, trespass 01, trespass 01, dealing in stolen property and theft 2000, trespass resisting without violence 2000, cocaine 98, a year and a day, grand theft auto 98, a year and a day, open container paraphernalia 98, end of record.
Hear that, Mr. Burgos?
Yes, sir.
Okay.
I just would like to resolve this so I can get on my way in my life.
All right, sir, raise your right hand.
Sir.
You swear or affirm the testimony you're about to give is the truth?
Sir, yes, sir.
All right, you can put your hand down. You understand that by resolving these charges, you'd be giving up your right to a trial. You'd be giving up your right to a lawyer at that trial. You're giving up your right to confront the state's witnesses, to call your own witnesses. You'd be also giving up the fact that you're presumed innocent of these charges and unless and until proved guilty. You want to give up all those rights?
Oh, yes, sir.
All right. Mr. Burgos, looking at your record, obviously you've been through the system before. You're not a stranger to the system. And the behavior I read in the probable cause affidavit, I mean, you're just asking to make a bad situation worse. At some point, you got to figure that out, right?
Sir, I need to clear my conscience. I know that.
I'm sorry?
I need to clear my conscience. I understand. I meditate a lot on the beach.
Okay. Well, with that record, anytime the police come up on you and it just, can make a bad situation worse, you're better off cooperating.
What? Sir, yes, sir.
All right. How do you plead, sir?
No contents.
All right. I'll accept your no contest plea and sentence you to adjudication 5 days Broward County Jail.
My guess is.
I already did my 5 days.
Yes, time served.
Thank you, sir.
Not 5 new
you
days.
Have a great day.
You too.
Thank you, Judge.
Stephen Syriacs?
Sir.
Good afternoon, sir.
Where's this?
We're going to look your case up.
Go ahead.
Oh. It's on the felony. He's entitled to RR.
All right, Mr. Syriacs, on these charges, you're entitled to be released on your own recognizance. If there's nothing else holding you, you will be released. Charges may be filed against you, so you need to check either the clerk's website or check your mailbox and make sure charges are filed so you don't miss a court date. You'll just end up with a no bond warrant.
Yes, sir.
Okay?
Thank you, Judge.
No. If I
as long as everything's good.
Mr. Farbar, do you have a Christian Malo there?
Judge, we don't have anybody else in custody here.
He's in Ryan, Judge.
Oh, he's in Ryan? Okay, thank you. Thank you, gentlemen.
Thank you, Judge. Have a good day.
He needs a French interpreter.
That's not.
Yeah, I know we need a French, but I don't know if we have Mr. Malo or not. Is Mr. Malo at Paul Ryan?
35. Thank you.
10 minutes from now.
This is Dale.
I don't see a defendant anywhere. Is there anybody at Paul Ryan?
I'm sorry, Your Honor, who did you
Do
meet?
you have a
So we had-
Christian Malo there?
Marla, I'll check and see.
No, it's a lot more serious than ammo. Lewd and lascivious exhibition.
Here.
This is from Friday. It's the bonds are already set. This is pretty much just to bring him back to explain to him what the bonds are. I mean, frankly, he seemed to kind of understand.
I'm sorry, ma'am?
He's coming down right now.
Thank you.
You're welcome.
We were gonna Judge Brown was gonna put him on pretrial. Turns out mom doesn't want him home. She's sick of it. Now toilets.
Mr. Malo?
Did I go? No.
Wait.
Yeah.
Yeah.
Have a seat. We're waiting for the interpreter.
Oh, can't.
Just have a seat.
So.
He needs to interpret everything fair, so I'll let the traffic know.
Yeah, the interpreter's on her way. She'll be here in a minute. Christian Malo?
Christian Malo?
Oui.
Good afternoon, sir.
Bon après-midi, monsieur.
You have been charged in count one.
Ils vous ont chargé avec le count numéro 1.
Lewd and lascivious exhibition.
Que vous êtes sorti vous avez sorti faire une exhibition non propre.
By an offender over 18.
Par une personne qui a fait une offense qui a plus que 18 ans.
And a victim less than 16.
Et la victime avait moins que 16 ans.
Same charge in count two.
La même charge pour le count numéro 2.
Count 3 is exposing your sex organs in public.
Le count numéro 3, que vous avez exposé vos organes privés au public.
And count 4 is the same as count 3.
Et le count numéro 4, c'est la même chose que le numéro 3.
You were here on Friday, I guess.
Vous étiez ici vendredi, je pense.
And the judge on Friday found probable cause.
Et le juge a trouvé une cause probable.
And set the bond at $20,000 on count 1.
Et vous a fait le bond, la garantie pour, I'm sorry, Your Honor. How much?
$20,000.
How much?
$20,000.
A fait la garantie, le bond pour $20,000.
$20,000 on count 2.
$20,000 pour le count numéro 2.
$100 on count 3.
$100 pour le count 3.
And $100 on count 4.
Et $100 pour le count 4.
As a condition of your release,
Comme pour condition pour sortir de la prison,
you're not to return to the beach.
Vous ne pouvez pas retourner à la mer, à la plage.
And you're not to have any contact with the victims or their family.
Vous ne pouvez pas avoir de contact avec les victimes et avec leur famille.
Okay?
Okay.
Okay?
All right. Have a good day, sir.
Ok, bonne journée, monsieur.
And that concludes our docket at 2:52. Carlos.